Welcome to the recording of episode 11 of the Family Matters Show. Facebook here. I'm Benjamin Bryant, accredited family law specialist at Bryant McKinnon Lawyers, and clearly I have Heather sitting right next to me. Good morning, or good afternoon rather, Heather.
Hi Ben.
We do these shows, sometimes we forget, as an aside to our real job in real life. And of course, as lawyers, we have to go to court, and today is no exception. These days, a lot of the court matters that we do are actually by telephone, where the judge rings in. I think we just got off the phone to a Brisbane judge, and so we have a New South Wales judge ringing at any time. If that happens during the next half an hour or so while we're recording the podcast, we'll get a little wave at the door, and Heather will have to leave us, and I'll do a song and dance, or no, I think we'll just cut the Facebook feed at that stage, and then we'll pick up when Heather's back in, because as you know, primarily this is a podcast recording, so we want to get the sound quality right, and it doesn't matter when we record it, we just like to try and get it consistently at this time on the first Tuesday of every month, so it's easier for you guys. With that, are you ready to go, Heather?
Sure am.
Welcome to episode 11 of the Family Matters Show. I'm your host Benjamin Bryant from Bryant McKinnon Lawyers, and I'm here today with my partner Heather McKinnon. Hello, Heather. It's community questions today, and I see we've got some challenging one this time.
Well,
Hello, Heather.
Why don't we start at the top?
Hello, Heather. It's community questions today, and I see we've got some real challenging ones. Are you up for it?
Hi Ben. Always up for community questions. These are some of my favourite shows because it gives people a chance to get their questions answered, particularly people who are just struggling with family breakdown and they don't want to go public. So it's a great way to be anonymous and get some good advice.
Agreed, and I was fortunate enough to be on holiday for the last show, but I certainly listened in. And Gemma did a great job standing in for me as host, and you gave some really great tips on how to keep the cost of divorce from escalating. I think that show is going to help a lot of people.
I certainly hope so, Ben. We missed you on the day, but I think Gemma and I held our own, and as we said on the show, no one wants a divorce that gets out of hand. Not even the lawyers want that. So we're always happy to chat to people about how to keep their legal fees in check.
And what I got from the show, Heather, personally, that particular show, was how accessible this podcast is, and just goes back to our intention of trying to give people, everyday people, access to information in such a complex system, in such a critical time in their lives. And I think I was laying on a beach and lawn somewhere or something with my iPhone, accessing and listening to the show. So that was really, powerful for me to be able to do that. And for anyone who is worried about legal fees during divorce, which I imagine is just about everyone going through the process, I commend last month's show to you. You'll find it on our website or by searching for the Family Matters Show wherever you get your podcast. And now let's move on to this month's show, where we'll focus on some great questions that have come from the community. A big shout out to all of you who have sent in your questions. We really appreciate you. And for all our listeners out there, you should feel free to send us your questions anytime on Facebook Messenger or email us at familymatters@bryantmckinnon.com.au, where we'll let you know when we'll be able to answer. Okay, let's get started with our first question. Are you ready, Heather?
Okay, it sounds like I'm in some sort of school competition here, but we'll see how we go.
Excellent. Question 1. My ex-partner and I have shared custody of our 2 children who are aged 8 and 11. I want to take the kids back to the UK to visit with my parents, and my ex is refusing to sign the passport application and says it's a breach of our custody agreement. What can I do?
Ben, as you know, this comes up a lot in family law matters. People are nervous about children leaving Australia to go overseas. But what the court does in these matters is look at what's best for children in every circumstance. So in Australia in the modern era, most children of middle class families get to travel overseas during their primary and high school years. But in this case, we've also got that issue of giving children a sense of identity and making sure that they spend time with the grandparents.
And
in the
life
UK.
experience.
Oh, that's right. So unless there was some reason that the court thought it wasn't in the kid's best interests, it would normally be the case that a judge would say, look, this is going to be fantastic for these children. They need to know their grandparents and they need to experience overseas travel. So what we normally suggest is that if you're the parent who wants to take the kids overseas, you start with a mediation if your spouse is not just saying you're okay. The mediation services at the Family Relationship Centre are used to helping parents work out the conditions of overseas travel. So the usual sorts of things we look at are how will the time be agreed? So if you're going to spend the money on airfares to the UK, then you're probably looking at a 4 to 6 week trip. And so there might be some negotiation around dad having make-up time when the kids come back if he lost some of the holidays. The sort of things that have to be agreed upon are how do the itineraries get exchanged, how do the children contact the parent who's remaining in Australia, and what sort of conditions are imposed in terms of the passports being released so the trip can happen, and also where the passports are held when the children get back. As you know, Ben, the main thing that the courts are concerned about is if the trip's got some sort of sinister purpose. For example, we have this thing called the Hague Convention, which is a convention under the powers of the United Nations that countries voluntarily sign up to. In the main, most Western countries are signatories. What that means is if these little ones went to the UK and the mum didn't bring them back, the two governments, i.e. the Australian government and the UK government, in signing the convention agree that the kids will be brought back. So if people are looking to go to countries that are not signatories to that convention, the court gets much more circumspect about making sure the trip's for a genuine purpose, because if the kids do leave, say they go to a Middle Eastern country or there's been some famous examples of them going to places like Malaysia, our government can't get them back. So you've got, in this case, UK, well and truly a country that abides by the UN Convention, assuming that there's nothing sinister. If this dad won't agree to allow the kids to go and the matter does go to court, it's likely that he'll face a cost application because the court would see it as bloody-mindedness, all other things being equal.
And that's on the basis that this parent would like the children to have passports to visit the UK, as opposed to visit and stay in the UK. That's an entirely different question. And I suppose, Heather, it's important on a practical level to advise our listeners that there are delays in the court system. So, for example, if you have plans or there's a party, grandparents' birthday or something on in June this year, you're going to have to act quick, because you mentioned Section 60R before, doing mediation to see if you can't resolve the issue before going to court. But if you were to go to court, in Coffs Harbour at least, if you were to file documents today, you'll ordinarily get a date in May or something. So because the court is so under-resourced and so there's delays evident, you really got to make sure that you get in quick if you have to get in.
Yeah, my advice to people is if they've got a trip planned, you need to start work on agreements at least a year before, because if the other side does get into some sort of fight mode, you need to well and truly know early on that you need the help of the court.
And Heather, the next question that we have also deals with some geography and a bit of relocation. I'm separating from my husband and would like to move to another town to have more job opportunities and to be closer to family. But my husband doesn't agree with me taking the kids. Do you think it's worth going to court, or is there no chance to get a judge to support my case?
So, Ben, as you know, this is one of the main sort of areas that you and I litigate in. These cases are broadly called relocation cases, where one parent wants to take the children to another area, either in Australia or overseas, and the other parent thinks that's not in the kid's best interests. So again, for those viewers who are used to listening to the podcast, the test is what's in the kid's best interests. So relocation cases are fascinating. I know you did one last year where one of the famous quotes from the judge was that the mother was like a butterfly pinned to the wall. There are all sorts of reasons that kids will be allowed to relocate with a parent, but there's just as many reasons where the court says it's not in the children's interests. We can't really tell you what's going to happen unless there is an expert report. At the time the court looks at the issues, the competing claims between the parents, we can start to get an objective overview as to whether it's worth spending the money to litigate. Up until that stage, it's almost impossible to tell. The sorts of things that regularly appear are, as in this case, job transfers because of an unusual profession where, for example, in the case you ran last year, we had a nurse unit manager and there was only one position available at her level in a regional area, whereas in the city she would have the opportunity to keep maintaining a high level income in a specialised field. That's got to be looked at with things like other kids settled and stable in their school communities, in their general communities, and does the parent really want to move for the best interests of the kids or just because they want to go. So they're really complex cases, everyone's different, but my advice is start in that mediation process, talking through the issues with your ex-partner about why you want to go. It's amazing what happens in those mediations. Sometimes the parents agree they'll both move to the city. So you never know what's going to happen until you start talking.
And here in Coffs Harbour, we do a lot of relocations, of course, because we're equidistant between Sydney and Brisbane, and that's usually where there's some conflict or a proposal to relocate with the children. And with relocation matters, Heather, I think it's a good reminder that, like you said, the paramount concern is the best interest of children, not of the parents or the convenience or necessarily even the employment opportunities of the parents. It's about the best interest of the children. And to also remind us that family law, by its nature, is discretionary. It depends on the facts of the circumstance, the facts of the matter. Each matter is different. There is no one size fits all. There is nothing in the legislation that says if your children are 7 and 9 and you intend to relocate 250 kilometres away, then you'll be permitted to leave. There's nothing like that, unfortunately. It's all discretionary. And when it comes to making an assessment of what's in a child's best interest, again, we said in previous shows, it's not about just a general thought about what's good for the kids. The legislation actually sets out at Section 60C what a court must consider when considering what's in a child's best interest. And one of the primary considerations, of course, with any risk factors, is the benefit of the child to have a meaningful relationship with both parents. And that's normally a really difficult limb in relocation matters, because if the relocation is significant enough, for example, Brisbane, where there's not necessarily good public transport between the two, it's a long drive in the old highway still. There's a lot of factors in there, with, whether they're young children, older children, or what have you, or if parents can afford to fly. But certainly involves change of school and a change of arrangements and things like that. It's really that kind of move will have an impact on the relationship between the child and the parent that is not going to move. So the court really needs to weigh that impact with also the benefit of children or a child being able to relocate. So it's really nuanced, really, there's discretionary in each matter. And you spoke about the matter that I did last year, and you talked about the employment opportunities of the mother. But I also remember the employment issues for the father in that matter, because his trade qualifications weren't recognised in Queensland. So it was part of his argument that he couldn't up and leave to Queensland as well. So there's a lot of factors to consider.
There is.
Question 3. I've been living with my partner for 15 years. We have no children and we've already agreed on how to split our assets, which aren't that much. I've just moved out of the rented house we've been sharing and I'm pretty much just getting on with my life. I have read somewhere that it costs $900 to get a divorce. Do I actually have to bother with this since we were never officially married?
Classic question, thanks to the person who sent it in. First thing that you need to understand is divorce just ends a marriage. So it's the court process that deals with ending the marriage. It doesn't have anything to do with finance. And as this person's rightly pointed out, if you're not married, you don't need to get a divorce. So the question's actually about when do you need to get a formal property settlement then? So in a case where you've been together, you've rented, and you just want to divide the furniture and vehicles and get on with it, you may weigh up that it's not worth formalising a settlement. So these sorts of issues that we need to talk about are when might that not be a safe thing to do, that is a handshake deal and you get on with it. You must remember that if you get a lot of money after you separate but before you've done property settlement, through something like an inheritance or significant gift or a personal injury claim.
Lotto win.
Even if you've separated, that still gets considered. So that might be, in a case like this, an outside risk. But certainly if you've got an inheritance that you might get because you've got elderly relatives, it might be worthwhile securing a line in the sand by getting a property settlement done. The big thing that most Australians fail to assess is superannuation. So if you've put all your money into super and you don't have real estate, it's really important when you separate that you get a lawyer to assess what the superannuation split would be if a judge was looking at it. Sometimes these people have hundreds of thousands in super, and in fact one might have hundreds of thousands and the other one has hardly anything. So I would say they're the two big things you've got to think about. Super and whether or not one of you could get something before you take the risk of not doing a settlement.
And I've said this on previous shows, Heather, but I think really what I would tell this listener also is that even if you don't do a formal property settlement and you might need a lawyer, you should get legal advice. You should get the information, because you making a decision to do nothing is you still making a decision, and you should make that decision with all the information before you. You mentioned a handshake agreement. Last year we resolved a matter just towards the end of the last year where parties separated. They sold the house and the net proceeds were divided equally. That's fine, and that was absolutely just and equitable. But there was a situation where they didn't do anything with the superannuation. They said, shake our hands, we don't need lawyers, we're doing it ourselves, we'll just walk away with our own superannuation. They never divorced, and then she came to us, I forget how long ago, but it was significant, like 10, 15 years of separation, in which he's making an application to the court for part of her superannuation. So even if there was a handshake agreement, of course it doesn't mean anything. If you're still married and there's no time limits that apply, you can still get a property application.
And I think it is the benefit of staying in a community like I have for nearly 40 years and seeing how often that happens then. People separate when they've got little kids, dad agrees that mum stays in the house and they don't do a deal. The last child leaves home 20 years later and suddenly we've got this almighty dispute on because dad's come back for his share of the capital. So get advice. It might cost you a couple of $100, but it's really one of those things where you've got to make assessments based on knowledge, not just what you think might happen.
And for this listener, they mentioned the fee of $900. That figure is not actually plucked out of the air. There is a filing fee of $900 that the Federal Circuit Court currently uses for divorce. So if you were to make an application for divorce, it would cost you $900 to make that application, unless you, or if it's a joint application, you and your husband or wife eligible for a discount, whether you're income tested pension or something like that. So that's where the $900 comes from. It's a filing fee for an application for divorce.
Which only ends a marriage, has nothing to do with property settlement.
And I might add that this podcast was recorded in February 2020. That fee will no doubt go up. The next question, Heather. I've been abused verbally by my husband for many years, but I don't want to use that argument in the court as I don't want people to know about my private life. Does it make a big difference to mention these incidents in my court case when I file for divorce to get more time with my kids?
So here's probably the most complex issue facing judges making decisions about kids. We've done podcasts before talking about family violence and the impact of family violence on children. In a case where children grow up in a household, even where the family violence is intimidation or verbal aggression, there will be impact on the children. So in a case where a person's looking at making arrangements for children, but they don't want to raise the issue of family violence, it's my strong view that you need to go to a social scientist who is skilled in helping people who've lived in that environment assess what the impact has been on the children and whether moving forward authorities need to assess whether the parent who's perpetrating the violence has a risk to the kids, not just the ex-partner. Invariably, that silence, that failure to deal with what actually happened in the household has huge ramifications for the kids later on. My view is bring it out into the open by at least discussing it with a mental health social worker or a psychologist before you make the decision to let your kids continue to go and spend time with the other partner without knowing what that impact's likely to be. For example, a dad who constantly yells at children will have profound impact on their self-worth moving forward. You need to get an education about why people who are aggressive to their children do long-term damage.
And to address the listeners' concerns, who actually hears the dirty laundry in the courtroom?
So in our system, most of the evidence is obtained by a family report writer who's a court consultant, who's a psychologist. They will initially be doing the assessment on how severe the family violence has been and how it impacts on the kids. You only proceed in litigation if those initial preliminary assessments suggest that the kids do need someone to look at giving them some protections. So initially it's all done in confidential counselling. It's done away from prying eyes, and you're only going to raise the issue if, with help, counsellors tell you that the level of violence is outside a range that the children can deal with without some protections. That's what my view is.
And as you mentioned before, Heather, we've actually tackled domestic violence and family law matters square on in its own show previously, so I'd recommend to our listeners to check out the podcast that we did with Dr. Andrews, Doug Andrews, in respect to that issue specifically. And there's a similar question, Heather, that goes into what we just discussed there, and that is this question. When we separated, my ex-wife and I agreed that we wanted equal shared time with our children, but now we are constantly fighting about it. She always wants to change the days of the week that she has the kids, and yet when I want to go away for the weekend, she refuses to change her dates. It is so frustrating. Should I consider getting a court order that stipulates the custody rules? In your experience, will that stop the fighting?
So what we know from longitudinal studies, the most important thing post-separation is that parents get a civilised method of communication. This case looks like, even though you've successfully separated, you're still having issues with flexibility, with communication, and with how you manage the day-to-day life issues that arise in the complex structures of families. So the first step is, look, you've done your best, but it looks like you need professional intervention. So we would say off to the Family Relationship Centre or a private family therapist to see if you can renegotiate the rules. We have two sorts of post-separation families. Those that are able to create a flexible environment that allows for changes in routines. So if kids have got a rep basketball tournament on in Townsville one weekend, that's mum's weekend, dad says, look, I'll take them and we'll swap the weekends. That's what sensible parents do. The other sort of families we have are those where the toxicity between the parents never abates. And so then our job is to create what we call parallel parenting orders, which is what this person's alluding to. That is, dad has week 1, mum has week 2, and never will there be any flexibility. The only way to stop the kids being exposed to conflict is to have black and white rules. And if your brother's wedding is on when your wife's got the children, tough it, the kids can't go. So the assessment we make post-separation in that first 6 to 12 months is, are you going to be in the 80% of families that create a flexible environment for the children post-separation? Or are you going to be one of these toxic families that need what we call parallel parenting orders? It takes about 6 months post-separation for the dust to settle in most households. If there's still ongoing angst after 6 months, then our view would be there needs to be a level of professional intervention to look at which style you're going to have long-term, parallel parenting or flexible parenting.
And I think it's fair to say that there are some real benefits of having court orders in place, but there are also real limitations. So the limitations are that, of course, a court order cannot change someone's personality. Do you know what I mean? They are who they are. A leopard doesn't change their spots, if you will. And it also doesn't give parents insight. Orders can't give parents insight or education or communication skills. That's something that happens separate to the court orders. But in addressing any power imbalances, especially in relation to, I know this couple said they're doing equal shared care, clearly not on a week-about basis, but when if you have a primary carer and then you have the weekend mum or dad or something, there is automatically a power imbalance, even though they would no doubt have equal shared parental responsibility or joint parental responsibility, and they have equal say for the children. The fact that one parent's the primary carer seems like they have more say. They have more say, and so what they can do is say, you agree to what I'm going to set out, or you're not going to see your kids, or something like that. And so orders are really good at addressing power imbalances like that, but they're not so good at the personality transplants.
Yeah, and look, the other message I'd give is, I've seen it for years, people assume that when they separate, kids' development stops. So if you separate when your kids are in infants primary and you're not acknowledging the growth in the children, when they hit high school, you're absolutely blown over by the fact that kids start to be the third party in the arrangement negotiation. I don't want to go to mum's this weekend because me and Sam are going to a rock concert in Brisbane with David's mother who's taking us up there. These things happen, life gets complex. Best thing is stay flexible. That's what I'd love to see for every family.
Because as we've learned over the years ourselves, but also our listeners, our regular listeners would have heard specifically from Dr. Ian Nesbitt about the effect that conflict causes to children. So children are really good at adapting and doing rock concerts with different people, or bedtimes, or new partners, new houses, new schools, those things. But they're not good at dealing with conflict. That is what damages children. So even though these parents might be thinking they're doing what's good on paper, they're sharing their time, the conflict could be still causing the children quite some damage or trauma.
Absolutely.
I'm just going to check in with our producer. Do we have time for more questions? There's a couple of more questions. Or?
Not really, but if you want to do one more.
Yes, I'm going to ask this question because I thought this is interesting, and a lot of people ask this question. I've been separated for over 2 years and recently filed for a divorce. To my complete surprise, my ex-wife now says she opposes the divorce and has filed a document with the court saying she's against it. What happens now? Does this mean I won't be able to get divorced?
Really interesting. People adjust to separation in all different ways, and we do get a small percentage who do try and stop the divorce. So in Australia, when a judge is deciding whether to give you a divorce, firstly they look at, were you married? Then they look at, have you been separated for 12 months? Then they say, if those two things are met and there's proper arrangements in place for kids, all over Red Rover, the divorce goes through. So you do get really sad cases of people turning up with Bibles under their arms, arguing with the judge that the Bible says they can't get divorced, or turning up with a witness to say that, you know, they can't get divorced because she still loves him, and they're really tragic cases. But the short answer is, as long as you've been separated for 12 months, it's very rare that a court won't grant a divorce.
Yeah. And in practical terms, or you have your divorce hearing, all you can really do is, you know, obviously she's been served with the documents, that's the biggest hurdle over and done with. You go before the registrar, and the registrar will ask questions. Ultimately, if you satisfy the criteria for a divorce, you will become divorced. Even if the separation date's not agreed to, but it's still been 12 months. Or even if you're arguing over whether it's Friday or Saturday night with the kids, the registrar would still be, be satisfied that there are proper arrangements in place. So the advice is just hang in there, go to the divorce hearing, and it's more than likely a divorce will be made, notwithstanding that there's some argy-bargy. And thank you again for those questions, and thank you, Heather. We really love being able to provide answers to help you through sometimes very difficult times. So please feel free to message or email the show at any time, and we will do our best to make sure your questions get answered. Next month, we'll be talking to family law barrister Rhys O'Brien about social media and family law. Rhys spends a great deal of time in the family law courts and has seen firsthand how a casual Facebook or Instagram post can affect a family law case. So, social media has changed just about everything when it comes to relationships, but as Rhys will be able to tell us, it's also changed how relationship break down in the family law court system. If you've got a story about how social media is affecting your separation or divorce, or a specific question about social media and family court, then please either send us a message on Facebook or email us on familymatters@bryantmckinnon.com.au. Before we go, one final reminder that links to any resources mentioned, plus a full transcript of today's show, will be available in the show notes on our website. Goodbye for now, and we hope you'll be listening again next month.